one.
Welcome, everyone. I can't believe it. We get the honor of being the last panel of the day, From Reform to Abolition, Learning from Experience. And we have a fantastic panel. First, a few announcements. Questions to the panel should go in the chat to me, and we will try to get to as many of them as we can via the chat function. So you'll tell me what your name is so I can give credit to you for your wonderful questions. At the end of this session, instead of breakout rooms, we're going to stay in the room, and you can all bring a glass. You can all fill the glass, and we will have a cocktail hour to end up this phenomenal conference. So we've been given a lot of intellectual food, and we'll be ready for other kinds of food as well. So with no further ado, I think that takes care of everything. And I'll have some announcements at the end to remind you where you can find these fabulous papers, and again, to invite you to the cocktail hour. So we have 4 papers. I'm going to introduce the participants alphabetically. So Anna Ahrens is here to give her paper, An Unintended Abolition, Family Regulation During the COVID-19 Crisis. Bill Betancourt and Kristen Weber are here to give their paper, Different Year, Different Jurisdiction, but the Same Findings. Reforming Isn't Enough. Melissa Carter, Christopher Church, and Judge Ernestine Gray are here to give their presentation on The Beginning of the End, How Judicial Discipline Nearly Eliminated Foster Care in New Orleans. And finally, Matthew Friedland and Shanta Trivedi are going to give us a role for communities in reasonable efforts to prevent removal. So we're not going in alphabetical order. However, our first paper is going to be Melissa Carter, Christopher Church, and Judge Gray. So take it away. Oh, and I should say, this is how we're going to go. Each of the 4 papers are going to have about 10 minutes to present either individually or collectively. Then we're going to have some cross talk among the panel, observations, questions, whatever, and then we'll open up to Q&A. So that's how we're going to go. Okay, Melissa, Christopher, and Judge Gray, take it away.
Thank you, Nancy. So hello, everyone. I'm going to start us off on this panel, and I just want to start by joining as all the other panelists have done, and expressing my gratitude to everyone that's been a part of this amazing event. I also want to say Melissa and I are going to do our best to represent our paper, which is also co-authored by Vivek Sankran, our friend and colleague who could not be with us today. And we've invited Judge Gray, the subject of our paper, to join us. So, you know, throughout this conference, we've heard a lot of data and data that reflect a pretty rueful reality. And so to wrap up our time together, I want to share some data that paint a little bit of a different picture. And to do so, I'm going to tell you about the Orleans Parish and a particular juvenile court judge whom I've already named that spent nearly 4 decades on the bench. And so that judge is Judge Ernestine Gray. And although she did not co-author the paper that is written about her, Melissa and I invited her to join us today for this panel because we thought you might like to hear from her as well. So about the Orleans Parish. So after a New York Times article dubbed the Orleans Parish Juvenile Court the worst juvenile court in the country, Judge Gray, who seems to have taken this personally, began making some changes that would ultimately have her presiding over every civil child abuse and neglect proceeding in New Orleans after the 72-hour hearing and through the time that the child was in care. That started in 2011, and around that time, there were over 200 children in foster care in the Orleans Parish. Judge Gray told us that she was seeing far too many children unnecessarily in her foster care. So she focused her attention on what my co-authors and I describe as a rather unremarkable concept, rigorously holding the agency to meeting its burden to justify family separation. So although the concept is unremarkable, the outcomes are anything but. By March of 2017, there were just 20 children in care in the Orleans Parish, 20 children in foster care in a city with more than 75,000 children in the population. So just to put that in context, if New Orleans had 285 children in care, its foster care utilization would have been comparable to statewide rates in Louisiana. If the Orleans Parish had 481 children in care, its foster care utilization would have been comparable to the national rate, but instead there were just 20. And even more, the children that were entering foster care in the Orleans Parish typically spent a matter of weeks separated from their family, contrasted against the years children more commonly spend in other jurisdictions. During this time frame, Judge Gray reduced the time Black children were separated from their families by 90%, which is truly unprecedented. We've examined child welfare, census, and CDC child fatality data, which all show that this reduction was achieved safely. What exists today in New Orleans is not a foster care system by any familiar standards. So I just want to wrap up my comments with this. We can imagine systems with new names, we can pass new laws, we can get rid of old laws, we can tinker around the margins, or as so many people have persuasively argued over the last 2 days, we can abolish. But whatever is left in our wake, if government has any role in meddling in the affairs of a family, you're going to want Judge Gray overseeing that system. She essentially eliminated foster care under our current framework and sustained that for more than a decade, which my co-authors and I are simply fascinated by. So I'm now going to pass this off to my co-author and friend, Melissa Carter, to tell you a little bit more about our ongoing study in the Orleans Parish.
Thanks, Christopher. It's great to be here with all of you this afternoon. And I've really also enjoyed, of course, the past 2 days and with such powerful testimony and such insightful thoughts about how we can go about doing better and actually achieving the outcomes that we all want from our work in the lives of children and families. The study that led us here to be with you today started with observing this phenomenon that Christopher just described. The New Orleans foster care system has nearly been eliminated by all regular measures, and that's notwithstanding and maybe perhaps despite the same federal laws and government institutions and other forces that create the inequities and the injustices that have been the focus of this symposium and the work of all of you and so many others. And we really just wanted to understand why and how. And so this is really just kind of a first look and a first start at that. We started with pairing the administrative data, some of which Christopher summarized for you, with the qualitative context of court observations involving Judge Gray and others. And again, what we discovered here wasn't revolutionary, but we find it to be inspirational because the results are highly attainable even within our current system. And the key as we see it is the judge who we brought here with us today, but importantly, what she models by way of a disciplined manner in which any judge would understand and fulfill that judicial role. The role of the judge, of course, has been the subject of much research and comment. Our host here, one of our hosts today, Jane Spinak, wrote a cautionary tale on which we relied. We know that lay people and lawyers alike might describe this role as being one of an umpire or a referee. It's someone who's an overseer of a process, a protector of rights, and an arbiter of conflict. We also know, and many of us have experienced, that the role of the juvenile court judge is only one version of what I've just described. It's a version of everything we just named and all of those functions, but also expected to be and frankly celebrated as being so much more. We all know this origin story of the juvenile court as a problem-solving court, as an innovation of the progressive social reform movement of the late 18th and early 19th centuries. But even then, and surely now, there's an alternative view that the court itself was not a substantive innovation, but rather merely served to institutionalize and legitimize social control, and particularly the practices of child saving. Regardless of your preferred theory of how we got to where we are today, the juvenile court exists today and operates today as much to address social problems as it does to enforce the law. And the juvenile court judge embodies these dual aims. We all know judges who will say proudly that their job is to save children. And that's very different, right, from that traditional judicial role that we might have described or surveyed people for responses to. The juvenile court judges, generally speaking, see themselves as arbiters of conflict, but also as problem solvers and also as agents of systems change. And that's in part because we, as a community of lawmakers, of policymakers, of practitioners, have called upon judges to lead in these ways. And we also prescribe the manner in which they do so. So reformers years back had called for greater collaboration between the court and the agency. And the law then codified that expectation, and best practice guidance reinforces it time and again. As one really visible example, the National Council of Juvenile and Family Court Judges Enhanced Resource Guidelines instruct that juvenile court judges in order to effectively fulfill their roles as gatekeepers to the foster care system and as guardians, as they put it, of the original problem-solving court, that they must engage families and professionals and organizations and communities to effectively support child safety, permanency, and well-being. So we have forged this kind of durable link between the outcomes that we seek and the role of the judge. And this view of the judge as lead collaborator goes far beyond an aspiration. It's widely accepted now as the gold standard for achieving these results of safety and permanency and well-being that are legally mandated for children and families. The problem with this approach is that it can undermine legal rigor and compromise the very outcomes that are being sought. Judges, as we all know, are not co-equals with the parties, and they do not have additional or different tools to solve the family's problems. We see that most pronounced when we talk about these cases involving chronic family adversity and community adversity, poverty. Yet judges often still act in an outcome determinative way. They exercise their inherent power to separate families based on a hunch or a therapeutic impulse that, again, is rooted in the origins of the juvenile court, rather than maybe in more rigorous or arguably proper inquiry into the legal basis for state intervention or the sufficiency of the state's efforts. The bottom line is that a judge acting as a collaborative partner and problem solver risks greater and unnecessary intrusion into family privacy, unwarranted family separation, and unnecessary infliction of trauma. And that's particularly true, we believe, in this pre-adjudication phase of a case. So Judge Gray's approach delivers a different blueprint, one that protects and preserves family integrity, and in so doing, one that fiercely guards the front door of foster care and all that lies behind it. She agreed to join us today to share her perspective and experience. I trust that you've all heard of her, and now we have the opportunity to hear directly from her. So I will conclude with that and turn it over to Judge Gray to share with you her experience, her approach to restructuring the court, and the results that she can stand behind and claim.
Good afternoon.
Good afternoon.
I'm happy to be here. I will tell you that I have consistently resisted Melissa's and Chris's identification of me as this person that I call the one and only. And I tell them in almost every conversation I have that I must believe and hope that there are other judges out there who are doing the same kinds of work. And so they tell me that's not true. But I will say that for me, when I became a judge in 1984 and I put my hand on the Bible and swore that I would uphold the law, that I took that to heart. And while the law has changed several times during my time on the bench, I was able to find in all those laws a piece that resonated with me, that guided my work. And that piece that I thought was consistent in all the laws was the protection of the rights of children and families. And then I added to it my own belief in the integrity of the family and the importance of having children being raised by their family. And I believe, as you know, I say all the time, we ask for a lot of research and then we get the research and then we don't follow it. When there's research that says among all races, the incidences of abuse and neglect are not that different, especially when you control for things like poverty. So the question for me was, in a jurisdiction where I am, where we were majority Black, why, we were not all Black, why I was only seeing Black children and families before me, which quite frankly meant, at first, I went through this thing of evaluating and saying to myself, are we vastly different, we Black people, vastly different from other families? And I believed in my heart of hearts that we are not. I know that we're not. We're all the same. We're all same people, have the same needs. And so I started saying, what can I do that will make a difference in the cases that I'm seeing and make sure that we're only bringing those cases to court that absolutely have to be there? And I remember early on, one of the things I think that jettisoned me out front early on was my saying that I believed in a country like the United States, it is absolutely criminal to be separating children from their families because there's no food in the refrigerator or because the house is dirty. And I kept that in the back of my mind. And when I got a call at 2:00 in the morning from the social worker, I would always say, what is the risk? What is the risk of irreparable harm, substantial risk that requires the child to be separated from the parent? You have to tell me what it is. And I will tell you, it's not a dirty house. It's not like a supervision. That's not it. You've got to tell me something that I can wrap my head around and really believe that if I do not give you this order, this child is going to be harmed. And I can tell you over and over and over again, that standard was not met. Now, I did not get all those calls in the beginning. I still didn't when I left get all those calls. Other judges got them, but then I got the case at the next hearing. And my question to the DA, the prosecutor, was, what is the risk that requires our intervention in this case, in this family, that is not going to let this child be safe? And if you can't say it, you can't verbalize it, I can't see it. It's not my job to make it up. It's not my job to figure out what it is. You have to tell me. And then if you give me the words, then I assess that. But my belief was that if I held everybody to what the law said, you have to establish probable cause for intervention. You have to meet the burden of proof to continue to separate the child from the family. And if you do not do that, if you don't make reasonable efforts, if you do not do that, then it's my job and my responsibility to say, no, you do not get to intervene with this family. And I can tell you that, that's not an easy thing to do. You wonder if you're making the right decision. You worry perhaps that if I get it wrong, what will happen? And the worry about if I get it wrong is always that the child is going to be hurt. It's never that if I get it wrong, the child is going to suffer and have limited contact with their siblings, limited contact with their relatives. That's never the consideration. And so for me, there are two sides of getting this wrong, right? And we don't consider if I get it wrong and I place this child in foster care and they grow up in foster care, their outcomes are going to be vastly detrimental, negative. And so we don't consider that as part of if I get it wrong. So what for me is, if I didn't do it correctly, there were two choices. Obviously, the child could be hurt. And many times that wasn't even a real possibility. If we intervened appropriately, if we sent them to a place where they could get food, instead of saying there's no food in the house and we're taking the children, if we sent them to some place that provided food for them, they would be safe. If we helped them clean up the dirty house, geez, what is a dirty house? I remember having battles with my daughter about her room and saying, if the social worker came here, they probably would want to take you away because your room is dirty. So what does that mean? And so trying to say to them, in this process of meeting your burden, it's not enough just to say words. You have to have some proof. And so if you think a house is dirty, that's a conclusion, which I'm supposed to make the conclusion, not you. The conclusion is for the judge. Because I've run into battles with doctors when they want to tell me what, the conclusion is that something happened or not. And I say, no, you give me the facts. The bottom line decision is mine. And I have to take responsibility for that. And so making sure that, we can say clearly what the risk is, that we can prove it. And when we don't have a case that meets that burden, we all should be coming to the same conclusion that this is not a case that belongs in the court. It really shouldn't be the judge making that decision on it alone. It should be together, because we all should see the facts the same. It's funny, Melissa mentioned the National Council of Juvenile Family Court Judges Resource Guidelines. I worked on the guidelines. I believe in collaboration, but not to the extent that it drives the decision. I tell everyone at the end of the day, the decision is mine as the judge, and I am willing to make it and accept the consequences for that. But what I require is the kind of attention, 150% dedication to the work to making sure we've gone through the process of identifying what the real problems are, what are the ways to address them, and then getting the children back home to their families as soon as possible. I believe that's what every family deserves. And quite frankly, I believe no matter what the law is, that if you change the law, if you do not have a change of heart and mind by the judges who are doing this work, you will have the same outcome under a new law, a new system. So I don't necessarily think we have to throw everything out. I think we really have to have heart change in mind of all of us in the system, the work of the judge, the lawyer, the bureaucrats, everyone, to get a different result.
Well, thank you for that phenomenal start. And next up is Bill and Kristen.
I'm going to double check because I thought it was Matt and Shanta, but I'm happy to go next.
Oh, I'm sorry. You're right. My bad. It's Matt and Shanta. Thank you for the correction.
Okay. Well, thank you, Nancy, and of course, thank you to the Journal and to the organizers of the conference, and of course, thank you to Professor Roberts for the amazing book that has meant so much to us all for so many years. I'm Matt Fraden. I'm a professor at the University of the District of Columbia Law School, and I'm presenting this paper with Shanta Trivedi, a professor at the University of Baltimore School of Law. And today we are asking you to take seriously what is really the biggest joke in child welfare. And I'm referring, of course, to the reasonable efforts requirement. And specifically today, we're focusing on the requirement that states make reasonable efforts to prevent kids' removal from their home before removing the child. And we are arguing that this mandate, the mandate that states make reasonable efforts to prevent removals, that it imposes a requirement on states to build communities with wealth and social cohesion so that the need or the perceived need to remove a child never arises. Judge Gray quoted herself asking caseworkers and district attorneys, what's the risk? And what Shanta and I are proposing is a way to minimize to minimize the likelihood that a risk will ever occur. So there are two pieces to the argument. First, we believe that states are required to engage in so-called primary prevention efforts to get out ahead of any problems that might ultimately cause a child to be removed. And second, we argue that those primary prevention efforts have to include building wealth and social cohesion in communities. We know these things work to prevent removals. And it's not reasonable, in the words of the statute, it's not reasonable to fail to do something that we know works. So if states haven't done those things, if they haven't made primary prevention efforts, if they haven't built wealth, if they haven't developed social capital in communities, they haven't acted reasonably in attempting to prevent a child's removal. So typically, as many of you know, this question's adjudicated very early in a case, generally right after a kid's removed. If the court finds that the state did make reasonable efforts to prevent the removal, even though they had to remove the child anyway, the state will receive reimbursement for a substantial proportion of the expenses incurred in housing the child in foster care. If the judge finds the state did not make reasonable efforts to prevent the removal, the state will not be eligible for reimbursement of those costs. But the reasonable efforts to prevent removal requirement has been a joke because virtually anything a state describes as having been an effort to prevent the removal is deemed by judges to have been sufficient to satisfy the reasonableness threshold. So for example, a state's attorney might tell a judge that when the child's family came to the attention of the state made reasonable efforts to avoid removing the child by interviewing the child and interviewing the parents. And if a parent appeared to have a drug problem, a caseworker may have given the parent a list of phone numbers so she could try to get help. Or if a parent expressed interest in getting a job, a caseworker might have given her referrals to job training programs. But lo and behold, these last minute 11th hour crisis-driven efforts purportedly intended to eliminate the need to remove the child didn't work. And so the state removed the child. And so what we're arguing is that preventing anything, including the need to remove a child, requires getting out ahead of the problem. And so in fact, what we're arguing is that it's not reasonable for states merely to respond to families' crises and then claim they've made efforts to prevent the need to remove the child. As Shanta will explain in a minute, we don't try to prevent teenagers from smoking cigarettes by waiting until they start smoking and then running around trying to yank the cigarettes out of their mouths. We try to keep children from ever starting to smoke by creating recreation programs and arts and crafts programs. We try to strengthen the schools. We do all the things that try to get out ahead of the problem so the kids never start smoking. And our argument, stated simply, is that states are required to do the very same thing in order to comply with their legal obligation to prevent the need to remove children from their families. Currently, what states do is too little, too late. And because so many removals, as we know, are linked to race and poverty, it's our argument that reasonable prevention efforts, reasonable efforts to prevent removals, have to address the structural problems of race and poverty. We believe the legal requirement that states make reasonable efforts to prevent removals requires states to do more than make the last-minute gestures that they currently get away with. Instead, based on our knowledge of how to prevent things, it's only reasonable if states make meaningful efforts to prevent families from having crises in the first place. Shanta, you want to take it away?
Thanks, Matt. I also want to say thank you to everyone that's a part of this conference. I feel extremely energized and inspired by all of you and your work, so thank you. So the field of prevention science is defined by the work of William Haddon, whose most influential work distinguished between prevention efforts that take place before an injury occurs from those that are implemented after the injury that serve only to reduce the severity of trauma. And in practice, what that looks like is campaigns such as the Truth Anti-Smoking campaign in the 90s that you might be familiar with, which was designed to reduce teen smoking by providing facts about the addictiveness of smoking, the number of deaths and disease attributable to smoking, the ingredients in cigarettes, etc. And the ads featured edgy teenagers, as they described them, of many different ethnicities to appeal to the campaign's target audience, teenagers. And this program was extremely successful at reducing teen smoking. So poverty-based removals are a perfect example of the types of cases where removals can be prevented by getting ahead of the problem. We know that most removals are due to so-called neglect, not abuse, and most of those are actually the conflation of poverty with neglect. So for example, studies show that about 1/3 of children could be home right now instead of in foster care if their parents had stable housing. So how do we apply this knowledge to the context of so-called child welfare? First, we need to create wealth in communities, and we need to provide supports that are disconnected from mandated reporting and child protective services. How absurd is it that parents' only option for support is to go to mandated reporters or CPS itself, the very people who could take your child from you, to ask for help? And as Angela Burton said yesterday, it's not rocket science. More money in parents' pockets leads to less CPS involvement. In Stockton, California, low-income residents were given $500 a month for 2 years, no strings attached. And this improved participants' job prospects, financial stability, overall well-being, and alleviated financial strain and generated more time for relationships. These are the kinds of things that lead to stronger families and stronger communities. One study found that increasing the earned income tax credit by only $1,000 reduced the likelihood of a child protective investigation by 7 to 10%. And recent research by Kelly Fong, who you heard from yesterday, and her colleagues showed that an 11.3% drop in substantiated cases of child maltreatment was attributed to the introduction of a single additional store that accepts Supplemental Nutrition Assistance Program, or SNAP, benefits in the most sparsely populated areas of Connecticut, particularly those related to insecurity, not rocket science. And then the second thing we need to do is to provide support. The late Gary Melton and his colleagues in South Carolina created the Strong Communities Initiative, which used volunteers and existing community facilities like churches and schools to connect with families of young children, provide direct support, and create larger social support networks. Community outreach workers worked with the community to solicit volunteers and created a network to deliver services within the community. They created family activity centers to host social gatherings and family resource centers that provided formal services such as healthcare and informal services such as social gatherings for Spanish speakers. And this gave parents a place to go when they needed help that was not CPS. It was not a mandated reporter. And all of this led to a reduction in parental stress and a reduction in reports of abuse and neglect. Similarly, in Washington State, the King County Blended Funding Project provided social opportunities and recruited parents to act as parent partners. And those parent partners would engage other families. And instead of relying on professional services, they used parents' individual skills to help others in the community. For example, one woman who had a history of drug use and was formerly incarcerated used that experience to support others dealing with those struggles. One grandmother who raised her grandchildren created a support group for other grandparents who are doing the same. And perhaps the example that's most on point is that in Florida, there was an experiment with a Title IV waiver where funds normally allocated to the state's post removal that Matt just mentioned were allocated to community-based service providers to engage in primary prevention efforts. As a result, the child population served by CPS was reduced by 29%. So instead of simply putting a Band-Aid on the problem, as part of reasonable efforts, states should be required to fund and create community initiatives such as these. Failing to provide primary prevention efforts is simply not reasonable.
Okay, fantastic, absolutely fantastic. So without further ado, so that we can further enrich this conversation, now we have Bill Betancourt and Kristen Weber.
Hi. Hello, everyone, and thanks for sticking with the last panel. I love actually being the last panel in some ways, but I also, we have rewritten and rethought about what we want to say, given that, when you're at the end, you want to respond to what everybody is saying. So I'm Kristen Weber, and I'm here with my colleague, Bill Betancourt, and we both have personal experiences with the family policing system, and we both have been working on and off for many years professionally to fight, identify and fight racism as we've seen it in the family policing system. And this paper that I'm going to talk about is work we've done around the institutional analysis and reform efforts, and how we've given up on reform, and really it's led us to conclude we really do need to abolish the child welfare system or the family policing system. And Bill's going to spend a little bit more time talking about that during the Q&A time. So, and I do also want to just say how I hope folks stay because we would love to keep being in conversation with everyone. So with that, our paper is about the last 15 years worth of work that we've been doing in various jurisdictions throughout the country to use what's called an institutional analysis, which is a methodology that identifies how the local family policing systems, how they're not working for Black families. We've also used it to look at the experiences of Latinx families and LGBTQ youth and families, but I'm going to be talking about our findings around Black families. And we originally started out with this intention that if we could improve the experiences and outcomes for Black families, that the experiences of all kids would improve. So it's this reform-minded way of doing the work and targeted universalism kind of thinking. But what ended up happening is that we documented for years incredible injustices and the everyday harms and indignities that Black families experienced at the hands of the family policing system. I'm not going to go into depth about what the institutional analysis is, but I'll just tell you a little bit about it. So this, the institutional analysis, which I refer to as the IA, we look at what's wrong with the system. And we were really just tired of how much research is out there about what's wrong with families. And we really want to spend time with what's going on with the system. Why is the system not producing the outcomes that it's supposed to be doing for kids and families? And so our paper is this compilation of that evidence over the last 15 years. And the institutional analysis, it examines the layers of systems and the features in systems. So we look at things like the mission statements of agencies, the job descriptions of workers of all levels, the concepts and theories that you've heard about a lot at this symposium today, but the concepts and theories that circulate continually about what's a good parent and who are these parents and youth and communities. We look at rules and regulations that govern what workers are supposed to do and administrative practices. We spend forever studying forms, intake forms and investigative forms and structured decision-making tools and any predictive analytic tool we can get our hands on. We look at how people and institutions are linked to each other and what information gets captured about a family and what information then is continues to moves forward with a family and what information is completely lost. And we do things, we also look at things like what are the resources that are available to workers, what are the resources in the community, what's the resources that are available to families. And most importantly, I would say we look at systems of accountability. So we look at things like we look at how workers are held accountable for outcomes for families, but we also look at how the system as a whole, and I'm not just talking about the individual protection agency, but we're looking at courts and providers and everybody and how they're all held accountable to families or how they're not held accountable, I should say. But we begin our work by getting permission from communities to talk to and understand what's the experiences of parents and older youth. And we ultimately want to understand their experiences in the broader context of their life. We know that the family policing system takes them up and captures one aspect, right? So when people are picked up by the system, they're labeled mother or father or child, and that aspect of that identity is sort of all that gets captured. We're trying to get a whole sense of what's going on and what it's like to live where they live. And it's a methodology that really is looking at the gap between what kids and families say to us that they need and what the system is set up to deliver. And so after 15, I'd say after 15 years and 20 of these institutional analyses across the country, we found the same things over and over and over again, despite the location, despite the size of the system, despite if it's a financially struggling system or one that has been labeled as a model system, we still see the same things. So here's my caveat, we have not gone to New Orleans. So I can't speak for Judge Gray's parish, but I will say that in the 20 places we've gone, this is what we've seen. And that the more work we've done, the clearer the racism has come into focus. And to put a finer point on it, it's the anti-Black racism is just oozing through everywhere. And we see reform efforts, when we see reform efforts, that structural racism is so strong and entrenched, it just morphs and mutates those innovations to be coercive and enhance surveillance of families. So I was going to read you a quote from our most recent institutional analysis that we did at the very end of last year. But I think, and it was about the lived experience of families and what we see, but I feel like I don't need to do that because if you listened earlier today to Anthony or Elle or Britt or Elizabeth or Vanya or Ashley, you heard all of that lived experience. And that's what we saw in 2020 and our most recent Midwest experience, but we also saw that in 2005, the very first IA that we've done. We see it in California, and New York, and Michigan, and Illinois, and Massachusetts, Iowa, just because we've done a lot in Iowa. But we've seen this over and over and over again, what the testimony is that you've already heard today. So while our paper goes into lots of detail about the common findings across the jurisdictions that we've been in, the one that I want to talk about just today briefly is just this, that our fundamental finding is that racism molds these family policing systems. And I want to highlight this because I get a little worried when I hear people talking about creating another system, because although we were looking in the child welfare system most specifically, we saw this in the prevention system, we saw this in the juvenile justice system, we see this in mental health system, and behavioral health system, that there is this overwhelming racism that is just shaping how families are interacting with the systems. And so I just want to, that we have to pause, and this is why we really are moving to reform isn't going to be enough. So just quickly, one thing we see, individual worker bias is alive and well, and it's largely unchecked. And all these reforms that are out there about training and coaching, it's not helping. It's just, all workers have some level of cultural competency training, cultural humility, implicit bias training, but there isn't this level of accountability about changing the judgments and behaviors. And we document over and over again this concept of parents and families that workers use in the family policing system. It's just riddled in the case files, and it's reinforced by the forms, the policies, and practices. So, you know, you all have heard this too. This parent is aggressive. This parent is non-compliant. This youth is hostile. This youth is psychotic. And they're not the facts that back up these labels that follow families throughout the course of their time involved with the family policing system. But we also see this more blatantly, or I would say about neighborhoods and places where families come from, and these coded ways about this is the West Side, or this is the Crescent, or people even say there are no strengths in this community. There's nothing that exists here. And this is what's in the mindset, but also reinforced everywhere a worker goes. So even if you get the best worker, a Black worker, a well-trained worker, there's no reinforcement within the system itself that allows them to act in anti-racist ways. Then there's no meaningful accountability. Second, there's no meaningful accountability to parents and children. And so these so-called interventions, they're not leaving folks better off. And there's no accountability to communities that are losing so many children, their social assets, they're losing them to other communities, whether it's other foster parents that are located outside of the communities or congregate care placements. And as Matt said, reasonable efforts is just a total joke. And so this level of accountability to families just doesn't exist. And then, as I was talking about just a minute ago, the new reforms come in and get morphed. So let's just take quickly family group conferencing, family team decision-making, family team meetings. Over and over again, we see this well-intentioned intervention coming in to give families a voice at the table or shift and to hear the family, let the family guide the decision-making. But what we hear from families is it's just another way that they get bullied and coerced, or it happens after their kids have been removed. And it's just about, will you comply with this set of services versus this set of services. So it's this innovation that just has come in and got completely morphed into something that it was never, I think, intended to be. And then finally, we just see this intensive and purposeful undermining of Black communities and Black family systems. And so we, as part of this methodology, spend time looking at the history of place and a history of racism in the place where families live and how that impacts highways and food accessibility and transportation and sort of all of those layers. And then we also then document how families are blamed for this larger disinvestment in their community. So at an individual level, they are blamed for not being able to get a job, or blamed for not having access to transportation. And over again, we see this level of sort of harshness on families. The other thing I want to say is we also see in communities that there's the people who are the groups that get these big awards for being community-based providers are often adjacent to the communities where families live, and they do something like, slant drilling, right? So they're these big community providers that don't really help families, but they get the big contracts, and the people and the groups that are helping families don't get the money. And so finally, just on this family level, where just this concept of family is so overwhelming. We replace one parent or maybe two parents for another parent or two. And we see that incredible disruption of the family web that so many Black families are a part of. And so families can't say this, I'll take this kid for 2 weeks, or I'm going to send somebody down, my daughter down south for the summer. That can't happen in this family policing system. But we also see things like kids can't go to family funerals or family reunions because not everybody has this criminal background clearance. Or even just on a very basic level, the way visitations are set up, it's always by default once a week, supervised, and it takes forever, or going back to court to change that up. So again, just wanted to sort of lay out really quickly that it's just sort of diseased in there, the racism. And reforms don't change these features of institutions that we talked about earlier, the mission, the systems of accountability. We just aren't seeing that happen. The reforms don't redistribute money and power. The reforms are about programs. And so, you know, I'm going to conclude by saying our work in many ways just documents the obvious, documents what some, you know, many people have been talking about at this symposium. But we are just seeing over and over again this gravitational pull of racism and how it's so strong. And so when you put reforms in, they just revert back into this system of coercion and surveillance and separation. And what we really need is this concept of escape velocity. And so I was listening to a high school student really actually talk about this most recently, and I was thinking about this is what we need for the family policing system. We need to escape this. That escape velocity is the speed that an object needs to be traveling to break free of planet or moon's gravity well and leave it without further propulsion, right? So for example, spacecraft leaving the surface of Earth needs to be going 7 miles per second or nearly 25,000 miles per hour to leave without falling back to the surface or falling back into this racism. And our paper is adding to the research about why we need to leave this planet of racism and family policing and white supremacy. And I'm so appreciative to be learning from and with parents and advocates and all of you about abolition, because abolition is the only way we really can propel out of this gravitational pull. And so later, Bill will talk more about this, but we're just, again, so happy to be with you all.
Bill, are you jumping in? Okay. All right. Because I love that background. Can you tell us just, Bill, before we, can you tell us about the background that's behind you? Because it's such a beautiful, can you unmute and talk about, just for a second, about the background behind your, you have the best Zoom background. Other than
I will be talking about that when you ask the questions, Nancy. This is about the upend movement that we're going to be talking about.
Great. Okay. So coming up. All right. Anna.
Yes.
You have, I mean, again, thank you for all these fabulous people so far. And here's another fabulous one at the end. Unexpected, unplanned abolition. So take it away.
Thank you. And thank you all for, I have the privilege and perhaps the burden of being the very last person to go in this conference. But thank you to everyone who has participated over the last few days and been present or involved in any way. I appreciate so much the opportunity to be a part of this. And I think to me, this moment, and by this moment, I mean, really within these last few days in particular, this feels like an exciting moment, maybe even a hopeful moment to have so many people united and engaged together in this project of abolishing the family regulation system. But outside this space, I think too often we get what Aaron Miles Cloud in the last panel referred to as these exhausting questions, these doubting, maybe snide, maybe ignorant, probably racist questions of how can you say abolition is realistic? What would we have instead? How could we keep kids safe? Or subtext, how could we keep poor Black, Latinx, Native kids safe without child protective services? I offer one real world answer to those questions, which is look at New York over the last year. During COVID, the family regulation apparatus in the city shrunk by approximately half as many reports, half as many investigations, half as many children taken from their families by the government and placed in foster care. The big takeaway is probably not surprising to most of us here. Even as the family regulation system shrunk to about half its normal size, children in New York City stayed just as safe. And they stayed safe not because of the family regulation system, but because of its absence. And because in its absence, families and communities found new ways to support themselves through the growth of mutual aid networks and new forms of government aid, granting families and communities the autonomy and the resources to meet their own needs. I'm going to spend most of my time today talking about the after, what the last year has looked like, but I do want to talk very briefly about the before in New York City. And that's the fact that even though New York touts itself as some kind of progressive bastion, this is a city with 8,000 children in foster care. I heard the numbers for New Orleans, and I truly had to double check to make sure that I had heard correctly and that I had my New York numbers correct, because I just couldn't believe the difference there. That's not even counting the number of children who are placed directly with their relatives. 90% of children involved in the family regulation system in New York at any stage are Black or Latinx, so that's investigations through foster care. 90% are not just not white, but are Black and Latinx, and the final 10% is white and Asian children, who together make up almost half of the city's children. And over the course of their childhood, 1 in 3 Black or Latinx kids will be subjected to investigations in the city. The investigations, unsurprisingly, also are heavily concentrated in poor neighborhoods. But last March, or I guess at this point, I should say in March 2020, 2 Marches ago, as COVID shut down the city, the family regulation system shrunk dramatically in 3 key ways in just a matter of weeks. First, the instruction of the state agency, workers curtailed their home visits and thus curtailed their surveillance of families in that setting. Second, as schools closed down, mandated reporters had less access to children and were less able to police them there. And finally, the family courts limited their operations, beginning to accept new filings only where the city was seeking to remove children from their families rather than surveil them in their homes under what's called in the city court-ordered supervision. These changes resulted in a dramatic shrinking of the family regulation system at every stage. There was a 40% reduction in the number of reports received and a similar decrease in the number of investigations initiated. And there were half as many new filings in family court. Especially of note, even though ACS retained its power to file new cases where it sought to separate families, only half as many children were placed in foster care as a result of ACS's applications for removals in spring 2020, as compared to a year earlier. This dramatic drop suggests to me that during the shutdown, ACS began assessing more rigorously the cases in which it would seek a removal, and as a result, holding off on filing some cases where it typically would seek a removal. And far be it for me to try to get inside ACS's head, but what this also suggests to me is that ACS was limiting itself to cases where it truly believed it could meet the legal burden for a removal, rather than seeking a removal for some other motive, for example, frustration with the parent's lack of cooperation, or some desire to punish the parent for some minor infraction per the CPS. In addition, on top of ACS asking for fewer removals, judges began granting fewer as well, which would seem to be counterintuitive in that if ACS were already exercising this extra layer of discretion before coming to court, you would expect that the cases that did end up in court would be more clear-cut cases for removal for the judges. But the judges too seem to pay extra attention to their legal standard, which in New York requires them to consider the harm of a removal to a child. And according to public defenders who were in court last spring, many of the hearings focused much more on this harm to children of removal during a pandemic, especially when in that moment, many children who were separated from their families couldn't get any visits with their parents at all, let alone the 2 visits that judges in New York typically expect. The fact that children stayed as safe despite half as many removals proves what parents and their advocates have been saying for years, that prior to COVID, ACS needlessly and baselessly separated thousands of children from their parents, often with the imprimatur of the city's courts. I keep saying that children have stayed just as safe, and I say that confidently based on several metrics. But I also should note that this is apparently now an uncontroversial position, despite all of the histrionic hand-wringing in the media that we all remember from last spring. Just earlier this week on Monday, the commissioner of ACS, Commissioner Hansel, testified in front of the city council. And his testimony was essentially that the city's children stayed just as safe. So going to the metrics that I have looked to, but I'll also add in some of what Commissioner Hansel noted. First, during the shutdown, the number of child fatalities reported to the State Central Register dropped by 25%. I should note, obviously, that child fatalities are extremely rare, extremely tragic aberrations, but they so often drive child welfare policy. And as you heard in the last panel, medical professionals, like all mandated reporters, are all too happy to make reports. So pandemic or no, they are very unlikely to underreport child fatalities. But again, there were 25% fewer reports in this period in spring 2020 as compared to 2019. The commissioner also noted that there had been no change in ER admission patterns and no change in the type of allegations. That is, there hadn't been an increase in abuse of children, and the breakdown of, I believe it's around 70% of allegations in New York are neglect only, and the remaining 30% include some allegation of abuse. That has stayed steady despite what you might recall from media stories of, parents who are stuck home at children at the end of their rope are just going to start beating their children, and we're going to end up seeing more and more of these very tragic extreme injuries to children. That just didn't happen. Second, there has been no rebound effect in the city. That is, even as children have begun to return to schools and public life has resumed and mandated reporters have resumed their surveillance of families, there has not been the expected uptick that we would think if their reporters had to catch up and report past concerns they've been unable to report before. At this point, the report rate is still lower than it was at this same point in the same year prior to the same month of the year prior to the pandemic. Finally, the rate of substantiation for reports has not risen. Even now, only about 35% of investigations find that any of the allegations were founded, which is the same rate as before the pandemic. Had mandated reporters returned to their positions and reported an influx of valid concerns from a backlog, we would have expected the rate of substantiation to jump higher to reflect that. I should also point out that this steady rate is even more noteworthy considering that past research shows that when agencies have fewer reports to investigate, their investigations can be more accurate and more thorough. Children stayed safe not because of oppressive government forces, but because of their own families and their own communities. As government forces receded, reducing surveillance and interference, but also failing to meet the basic needs of many New Yorkers, thousands of New Yorkers engaged in transformative projects, building up mutual aid networks. These networks that are built on models of solidarity, collective action, and transformative change, rather than charity, saviorism, and control, grew in every borough, providing everything from food and diapers to childcare to counseling services. Their growth was astronomical, and in just the first several months of the pandemic alone, they distributed along the lines of $1 million to fellow New Yorkers. At the same time, more New Yorkers received financial assistance from the government with fewer strings attached in the form of increased unemployment benefits, along with the stimulus checks. And together, those two forms of government aid represent the largest transfer of funds from the government to the people than all other non-retirement programs put together. I should also say I don't want to present either of these initiatives, either this increased government aid or mutual aid networks, as utopic or perfect. Particularly the CARES Act included the same kinds of tests of worthiness, for example, excluding undocumented immigrants and their families, and a certain level of jumping through hoops. For example, people who had not paid taxes in the previous year had to go through additional steps in order to get funds from the government under those programs. And likewise with mutual aid networks, and particularly mutual aid networks built up by white gentrifiers in gentrifying areas, there were many that came to resemble the hierarchical white dominated nonprofits they purported to replace. And I would say many of them remain a work in progress in that sense, although there are other mutual aid networks, especially several in Brooklyn, that pre-existed COVID and are more community-based, more grounded in, for example, Flatbush, a historically Black community where they've had a mutual aid program in place for decades already. But even these imperfect interventions, the government funds and the mutual aid networks, as compared to programs like Back to Work and SNAP, or compared to ACS-sponsored preventive programs, represent less onerous, less restrictive means for communities to support themselves. And should go without saying, they are not just another form of policing. These are not forms that are immediately going to filter back into the family regulation system and back into family court and back into foster care. Instead, these programs empower families to spend their own funds as they see fit and to meet their own needs in the way that they find to be best for their families. I end by saying that for me, the project of abolition is fundamentally a hopeful project. It's a project of creation, generation, and optimism. I say that recognizing that, to put things mildly, 2020 was not a hopeful year on many, many fronts. We had a pandemic that killed 500,000 Americans, with Black, Brown, and Native communities disproportionately bearing the brunt of those needless deaths. The pandemic spurred the worst economic crisis in a generation. It kept the thousands of parents and children who were already embroiled in the family regulation system separated from each other for even longer. And this all happened against the constant drumbeat of police murders of Black Americans. But I would argue that this death and destruction, this rupturing of these many interlocking systems of oppression that power this country, created a window into a different world, one in which more children live safely at home with their families in the absence of the family regulation system, one where we address child poverty and child safety by providing families the monetary support they need without strings attached, and one where we build and rely on robust community support networks governed by principles of solidarity and collective caretaking rather than punishment and moral judgment. This world that I just described is not some idealistic pie in the sky, impossible dream. It has been for much of the last year a reality in the country's largest city. And I think the challenge now for all of us is to make this more than a fleeting moment and to make it our sustained reality.
Wow. Boy, did we all need a silver lining out of the pandemic? I think that is one of them, a most unexpected one. So originally the panel was I was going to give everyone an opportunity to comment on each other's presentation, but the presentations themselves have gone a little longer than we had planned, but so rich, such incredible contributions. So instead, I propose that we move to Q&A, and I want to pose a question to the panel. So I'll start off, and then and that may provide an opportunity for comment on each other's work as well. So if abolition also includes reconstruction, what would be your short description of your vision? Short description of your vision. I know I'm asking you to distill a great deal. And then if with that vision, imagining that you were presenting it to a public audience, not a receptive set of folks as are at this conference who would probably all go, great, wonderful, let's do it. But to the public, what do you think is the greatest challenge to your vision? And what do you think is most persuasive about your vision? So unmute yourself and jump in. Actually, Bill, you had mentioned that you were ready for this. So Bill, how about I call on you?
Yeah, sure, you can call on me.
Okay.
You know, over the past 2.5 days, we heard a lot of ideas, thoughts, people doing actions around categories I would call dismantling the system and envisioning a new way. I've worked in reform efforts for over 30 years. I'm now in recovery. I'm an abolitionist. I do believe we do not need a better system, a newer system at all. We need to end a racial capitalist system that is prioritizing the accumulation of wealth, and instead put in place an economic system that prioritizes people, where communities have all the resources needed to be safe, healing, and self-regulating, where children, families, and communities can thrive. I would say that the folks that want to provide services, that want to provide what's needed for safety in communities should live there and be part of them. That would be a vision. It's going to be a challenge to challenge all of that. But it's time for action. We have an Upend movement. You can go to our website, upendmovement.org. That's the background you referenced, Nancy. And we have produced, which you can see on our website, ideas about dismantling and imagining for folks to begin to work with, that we call How We End Up. And they were released today. They're on our website. Please look at that. We would ask and encourage all of you who are interested in being part of a movement to join us and to go into the website and look. Our vision is that there is a whole array of voices and actions going on across the country, and a timeliness for us to build a movement. Upend is not part of any one of our organizations, but rather it's being incubated to become its own entity. And this year we will be moving forward with a process to have an inclusive designing process of what that movement might look like, where a multitude of voices and activities can become what I would envision like a chorus of a national movement to push at the federal and state level the way to end and propel us, using Kristen's idea, to propel us out of the white supremacist racist system that is the history of our country that lots of us are trying to stop from being taught today. So that's kind of the vision. It's a huge challenge, but it's time. It's time for action. It may not happen in my lifetime, but I hope to God we get it going before I make my transition. I don't plan to do that for quite a while, actually.
Can you share with us, Bill, where this is physically centered?
Where it is physically centered,
Like the geography.
Right now, it's connected to the Center for the Study of Social Policy and the College of Social Work at the University of Houston, and we are in conversation now about how to move it to the next phase of independent entity and a design process that I described. And where it ultimately ends up is going to be part of the collective thinking and designing that we do together.
Cool. Very cool. Who'd like to go next? Your vision, what you see as the challenges, what you see as the strongest persuasive.
I don't mind taking a stab briefly.
All right, Chris.
I will say that I do find it so awkward to talk about Judge Gray when Judge Gray is in the room, but I only have myself to blame for that. But I will say she used to be up in the corner and she's now somehow moved right next to me, and that's making it even like more awkward. I will only
She might reach across if you don't watch out.
I think the quick answer to your three questions is that whatever comes after, if the government has any role in that system, then that system has to include someone like Judge Gray. If they're determining eligibility, if they're doing anything that examines the appropriateness of something to families, we need that discipline on the bench. I think the challenge is to persuading the general public to that. You don't have to look any further than the Washington Post article from a few years ago that raised some of the critiques about her approach. I love that Anna brought out the data from New York City. We know that that COVID cut our system in half for the year that we went through that horrible pandemic and are still going through. Judge Gray cut it 90%. The reports didn't go down. The requests for removals didn't go down. What went down is when she had control over that system, the oversight of foster care, and she sustained it for a decade, not without controversy. And so I think that's the challenge. The persuasiveness, unfortunately, is in the rigor of the data that we're examining, and trying to get that down to a soundbite, I think is really challenging. And so, but to me, if government's going to have a role, we need people to really hold those systems accountable and make sure that they're doing right by the families and the children that they're designed to serve.
Well, Judge Gray, I have to invite you, since we now have as one of our visions is the Judge Gray model. What you would say, what your model would be if someone, again, said, you've had this on the ground experience, you're now in charge. What's your vision? And what would you see as resistance to that, or the persuasion? In other words, you are not bound by your judicial role at this moment.
Oh, I never considered that restricting. Um, I was always cautioned that, you can't do that, you're the judge. And I always said, well, if I get it wrong, there is a higher court that will tell me what I need to do. So until I'm called down, I'm going to do it this way. So I was thinking, so my view would incorporate a lot of what Matt and really talked about. So remember that thing that it takes a village to raise a child? And so when I listened to Matt, and I agree that where we have to focus is the providing of services on the front end, primary prevention, before there is ever any harm. I always talk about that both in the child welfare side and the delinquency side. We make a lot of noise about trying to help victims, but that doesn't really help because you can't unring the bell. You can't bring the son back. You can't have the person not be raped. So you have to figure out how to stop these things from happening on the front end. And so for me, the primary prevention is a big piece. And then I think what needs to happen is the belief in the value of family and a belief that all families want the same thing that we want for our families, the ability to live and grow without surveillance in peace. And that when people need help, as sometimes we all do, one kind or another, there's a place that they can go where they're not demonized because they need help. They are not afraid to ask for help. They can ask for it, feel that they're going to get it in a fair manner, and be able to survive. And so I think the preventative piece on the front end, bringing in the local communities, the people who live in the communities, to help do the work, I think is the way it has to go. And so who will you get opposition from? I guess the bureaucrats, I'm not sure, will probably be, and the people who believe that you actually you cannot save children without having a system, right? And that this system has to save children, not the families, not the community, but a system that we create has to be the one to save children. And I just don't think that is really the way to go.
Thank you. Who else would like to jump in on this? Matt, Kristen, Melissa, Anna?
I don't have anything to say except I'm curious if anybody in the big room has a reaction to anything that any of the panelists said.
Okay. Any other responses on the question I've thrown out, or otherwise I will take questions from the chat that have come up so far. So anyone else want to, Anna, did you want to jump in?
I'll just jump in very briefly. I think that unsurprisingly, my overall answer is essentially in line with everyone else's, that we need to be putting communities and putting families in positions where they don't need to be involved in any kind of system in the first place, which means giving them money, but also means making access to services possible without tying that to any kind of apparatus of policing, whether that is only having access to mental health care or substance use treatment or whatever, once you're already embroiled in the family regulation system, or in New York, only having access to preventive services once ACS has already received a report about you and is monitoring you. But I think kind of more fundamentally than that, and this is, I think, kind of the bigger question, is I think that there needs to be a reckoning with the fact that this is an incredibly racist, classist, sexist system, in that if there is not that reckoning, I think we end up exactly back where we are right now. And I think that part of that too is getting to a place where we grant the same kind of assumptions and privileges to poor families and Black families and Latinx families that we do to white families, right? If a mother on the Upper West Side has some kind of mental health issue, if she's depressed, if she's going to commit suicide or something like that, no one's reaction is, let's take her child away. Everyone's reaction is, this is a family tragedy and let's all figure out where this kid is going to go until mom gets better. And that's an informal arrangement that we all are going to agree and respect. Whereas if that same thing happens 40 blocks away up in Harlem, that immediately becomes a situation where the child is being placed in care, the family is not being trusted. I have a vivid memory of a client of mine who recognized in herself that she was having the symptoms of at the beginning of a bipolar episode, and she sent her child to New Jersey to stay with a family member. And then ACS found out about this, decided the family member couldn't be cleared, sent a caseworker to New Jersey to pick up this 4-year-old at the George Washington Bridge. And just the case note of this 4-year-old being ripped from his grandmother's arms to be brought back to be with a stranger when his family had made adequate provisions for him. I think that's the kind of thing where I can say all I want about giving more funds, giving more support, all of that. But if we don't fundamentally change kind of and confront the racist underpinnings and assumptions that are driving and motivating this entire system, I don't know that we have a sustainable path forward. I think, how do I present that in a way that compels everyone to agree with me? Great question. And, I think that's maybe something I'm still working out, but I think that we can't just kind of leave that piece out of it.
I just want to jump in here to what Anna's saying about we have to have a serious conversation around reparations. And there are families that have been harmed and continue to be harmed. And we can't just sort of say goodbye to the family policing system and not repair, not apologize, not restore, and really do that investment work. And I don't mean just individual families either, but communities too. And so there's that piece. And the other piece is just, I'm really wary about looking to universal systems that currently exist without also doing the anti-racism work to rid these systems of who gets privileged and who gets great services and who doesn't. And just think of your school systems, right? So where I live in Alexandria, Virginia, apparently 40% of the white kids are gifted and talented. It's amazing here. And they get a lot of nice supports. And Black and brown families really are fighting to get into and sort of see what is this nice service. So that this nice gifted and talented service. And that gifted and talented program is because of our legacy of integration. And it's a carve out to keep white kids in our public school systems. So I just want us to think about when we're talking about prevention services or any kind of services, we have to do these we have to be vigilant and guard against the racism that lives in these systems, and we have to root them out. And I'm not about convincing people, honestly. So I hear your question, but I'm too tired. I'm middle-aged now. And so I'm going to leave it to somebody else to do it. It's convincing.
So Nancy Polikoff, I want to ask you, we're at a point time-wise where I think we're supposed to be wrapping up, or should we continue to take some questions? What would you like us to do? I know that we're at the very end of what has been an extraordinary session, but I don't want to try everyone's patience by going further. So should we go to continuing this and formally end the session and continue talking, or what would, Nancy, if you'd like to chime in and say how you'd like us to proceed at this point?
You have until 5:30. That's the official end of the session. And then the breakout rooms, which you've already said you guys are all going to stay together. So the cocktail hour is from 5:30 to 6, but I would say you've got another 8 minutes until our tech people stop the recording of the session itself. So go for it with your question.
Okay. I thought one of the notes that is in the chat is from Martha Winokur. She says, ironically, as you all speak, the California legislature is considering a bill that would expand mandatory reporting to most volunteers in youth serving organizations. It is driven by insurance concern and legislative fear of appearing to be soft on child abuse. So I thought I would read that out. Let me go to this comment and perhaps question from Michael Moore. He says, question for the entire panel. Congress has already done the work to vilify family preservation as something inherently dangerous in the 80s and 90s. The propaganda from that era is still deeply entrenched in public awareness. So here comes the question. How do we lead an abolition movement with hope, knowing that the system will push back with the same misleading talking points and create further harm in its pathologizing of marginalized communities as a way to justify the status quo? So that's his question. And then his last comment, my personal advocacy has not been very effective in the social and professional circles, at least not to the degree that I would hope for. I feel like I'm fighting decades of social conditioning of the public to believe in the integrity of the family regulation system. So who would like to comment and respond? Jump in, Bill. You'll have to unmute yourself.
Sorry.
Bill, you've got it. There you go.
Yeah, there I go. A little tech problem on my end, old people. I think that the questions that get posed and the way that it's positioned as if the system is doing this savior stuff needs to be, by us, we need to learn to articulate how we can say and answer that differently than we have in the past. Which from my perspective is to say, because you keep putting that out and we still have the same outcomes, you are actually making our case. You're making the case for abolition. When you say, what are you going to do about all these kids that are seriously abused? They're still getting seriously abused, and what is the system doing to stop it?
Mm-hmm.
We have to look and find a new way. And we have to kind of say, those are all good questions. We get it. In the meantime, let's start dismantling it through actions like ending ASFA and et cetera, et cetera. But let's begin to collectively step back and try to imagine a better way.
Matt?
Yeah, thank you. So a couple of things we can do. One is what we're doing, what we've done over the last 2.5 days is get together and be strong together and spend some really important and exciting and safe time with fellow travelers. And so I think that's a huge part of making the kinds of changes that we're talking about. I think the other on a much more sort of prosaic level is that advocating to get these proceedings from out behind closed doors, having this stuff done in secret behind behind closed doors with sealed, closed off court files means that our group of fellow travelers can't grow all that much. But I do believe that if people could see what goes on, what Judge Gray saw, why am I seeing only Black faces? Right? I mean, it's not just true in Orleans Parish. It's true in Washington D.C. and it's true in so many other places. If people could come into the courtrooms and reporters could come into the courtrooms and tell stories about what they see, I think that is how we can start, building our group and really making change. Otherwise, it's just all going to be done in secret, and things don't go very well for vulnerable people when power is being wielded against them in secret proceedings.
So can I respond to that a little bit? Can you hear me?
Yes.
So I want to have us think about the unintended consequences of actions that we might take. So Matt raised for me one of my concerns in the press. Having had many opportunities to interact with the press, number one, they only want to come, even if I open my court, which, we have opened it for certain things, they only want to come for the really, really horrible story. And when they come for the horrible story, they don't get it right. They get a 30-second, one sentence that I say out of context and put it in the story. I'm only willing to do that if I can figure out how to work with reporters who are committed to and understand the context in which they're writing these stories, understand about the racism that we've talked about, and then can report a story in a way that is, fair. It doesn't matter to me. I mean, I've been vilified in the press and, before. So, but if we want the public to really understand and be supportive, we've got to have people who can tell the story in a way that resonates with the public. They can understand it and understand really the need for them to, one, be supportive, be concerned about what's happening to children and families in the court. And I don't know that necessarily what we get now from a reporter gives us that. But I've advocated, every court ought to have some reporter on their team, so that when there is a story, the judge or the court administrator can say to the reporter, here's something that needs to get out about what's happening in the court, and trust that that reporter is going to do a job about reporting what needs to be reported.
Well, let's, and we have a member of the audience who has raised her hand. Kimmy, if you would unmute yourself, then you can ask your question.
Okay, first of all, I'm just really happy to be here. I acted as a community activist in New York City. Specifically, I was working with families in Brooklyn. I've been to Queens, Manhattan, basically all the boroughs, and the violence and humiliation was always the same. So I had a question about how do we hold the lawyers and the judges who are deliberately dividing families and destroying American children and parents? Why are we not discussing imprisonment, trials? That's always been something on my mind. Why is nothing being done to hold them accountable for the violations of the constitutional law and our human rights, which is happening? It's just human rights violations, and no one's speaking about that. So I was just curious about any of the panel's thoughts on that. Thank you.
Anyone want to take that on?
Who, me? Maybe as a judge on the panel, I'll try. There are various ways in which you can hold a judge accountable. And so it depends on how judges get to their position. I will just say in Louisiana, we are elected. And I always told, and so I had to run for office, and I always told both the people in the court and the public that, I worked at their pleasure. It was not my job. It was their job, which they allow me to have this position. And if at any time I did something that they were not satisfied with, they had the opportunity first to go immediately to the Supreme Court, which in our state oversees the actions of judges. And there is a judicial commission, which if you have a complaint against a judge, you can file a complaint against the judge. That's one way. The other way is then when lawyers who are representing parties in a case, and that the judge makes a decision that they believe is not the right decision, that infringes on people's rights, the lawyers have a responsibility and obligation to take an appeal, which is a request to have it reviewed by a higher court. So you have reporting the judge to the Judiciary Commission or whatever the oversight body is for the judge's conduct. You have the appellate process, and depending on how they get their position, like you can you can have a recall petition, or you can wait to the next election and vote them out. Or if they're appointed by the legislature, I guess you could go to the legislature and complain to the appointing authority of the governor about the judge and how the judge is not doing what they're supposed to do and how their actions are really hurting the citizens, and encourage some action in that regard.
Well, I hate to say, and Anna, do you have any last comment? Because I know you have to leave us, and you inspired so much great thought and conversation. Any last words?
All of my previous words were, the best I could do. But thank you so much, all of you. And I'm gonna, stick around for another couple minutes, but then we'll disappear from all of your screens. But thank you to everyone from the last couple of days.
And I think now we are at a point. Well, first, I want to thank this amazing panel. So I hope you'll join me in, a round of applause for this amazing, amazing group. And they have agreed to stay and hang out. So now this is what happens. So I guess some people may want to leave. And before they leave, I would be remiss if I did not thank Nancy, Jane, and the Columbia Journal of Race and Law, and Dorothy, the inspiration, for this amazing, amazing conference. All of the presenters' work will be published in 2 issues of the Columbia Journal of Race and Law, the first of which is going to be available online on the journal's website in July. And the second issue is coming in the fall. And then in the blog portion of their website, there are additional voices of Black feminists, the Wabanaki people of Maine, LGBT youth, immigrant families, Global Mothers Network, and a child abuse survival. So great resources. So now, instead, for this last breakout, which actually we're going to all stay in the room, my panelists encouraged me to not just have an empty glass, but a full glass of wine. So if you want to go get your favorite beverage, and we'll take maybe a 30-second break, and then we'll continue on. There are messages in the chat that I can share with the group. But again, thank you, everyone. And then either send me a message or raise your hand. And okay, so while everyone's maybe getting their favorite beverage, let me just tell you a couple of things that came up in the chat. One person